Hey there, I'm estate planning attorney Paul Rabelais, and in this video, I'm going to really at a basic level discuss the differences between a will and a trust. So when people who have not had significant exposure to the intricacies of estate planning get to a point in their lives where they know they need to get their legal affairs in order, their first thought is often, I need to get a will. And then when they dig into the subject matter somewhat, either by reading information online or talking to friends or watching my YouTube channel or talking to relatives or other professionals, they often hear things like, you need a trust, or we created our trust 2 years ago, or my father passed away 3 years ago and he had a trust and it made the settlement of his estate easy. So then you get confused. You're thinking, do I need a will or a trust? What's going on here? So let's start at a basic level and discuss the differences between a will and a trust. A will, also known as a last will or a last will and testament, is a legal document that you sign providing who will receive your estate when you pass away, and it designates the person in charge of making sure that your wishes expressed in your will are carried out. This person is typically referred to as your executor or personal representative. When you pass away with a will and assets like a home or a business or investments in your name, your executor and heirs will go through a court and attorney involved process called probate, where a judge will sign various court orders that your will is valid, that your executor is enabled to deal with estate issues, and a judge will oversee the distribution of your estate to your heirs pursuant to the terms that were expressed in your will. Many people perceive this court and attorney involved probate process that is required when you pass away with assets titled in your name as being expensive, time-consuming, and an all-around hassle, because in many instances it is difficult and cumbersome to get through. Now, there are many different kinds of trusts, but when people compare wills with trusts, they are typically comparing a will with a certain type of trust called a revocable living trust. The concept behind a revocable living trust is that your assets are titled in the name of your revocable living trust when you pass away. Those assets in your trust when you pass away, they're not frozen, and they can be dispersed to your heirs, called trust beneficiaries, when you pass away without the expense and delay of a court probate proceeding. Things in a trust don't have to go through that court process. When you set up your revocable living trust and title assets in the name of your trust during your lifetime, then during your lifetime, you do whatever you want to with your trust assets. But when you pass away, the successor trustee that you designated in the trust instrument can make distributions to your designated trust beneficiaries without having to get lawyers and courts involved, as they would if they had to use your will to go through probate to gain access to your estate assets. What makes this analysis even more confusing is that when people consider a trust because they want to make the settlement of their estate easier, they ask, so do I have to put everything I own in my trust, including traditional IRAs, Roth IRAs, 401k accounts, annuities, life insurance policies? Well, no, because you are likely to own certain assets that are classified as non-probate assets, like IRAs and other retirement accounts. Because you can designate primary and secondary beneficiaries on these accounts who will receive the assets in these accounts when you pass away, these non-probate assets avoid probate by their nature. So you don't have to transfer the ownership of these accounts to your trust during your lifetime. Okay, so I hope that helps. Make sure you like, subscribe, comment, and a lot more coming on future videos. Cut. All right, so I'm going to give a little commentary to my video, something I'm going to start doing because I like to give the formal version and then just a simplified version. This was really just estate planning 101. And for the last few months, I've been digging deeper or doing a deeper dive, But I was hoping to bring more kind of newbies into the channel who are just getting started. Maybe if you know somebody who wants to consider doing some estate planning, you may want to share this video with them. So looking forward to receiving the comments. We're going to get comments on, what happens to your taxes when you have a revocable living trust. That's the topic of another video. We're going to get comments to this video on, can you help me, Paul, because I live in such and such state? Answer is yes, but the long answer is going to be in another video. When I talk about the difference between wills and trusts, in the comments you get lots of comments and questions of things like, what's the difference between a revocable trust and an irrevocable trust? Again, another video. And then there'll be the comments asking the question, Paul, if you have a trust, do you also need a will? Another video. And then anytime I do any kind of estate planning, will, trust, talk about beneficiaries, lawyers in a video, feel free, look forward to reading about those because we get lots of them. Your probate horror stories, your stories about how a family member acted inappropriately during a probate and it ruined relationships and it ruined the settlement of the estate. I'll probably get in the comments a few lawyer horror stories, and then you'll get those people in the comments that are like, thanks, Paul, we did our trust 2 years ago, 5 years ago, and this kind of serves as validation of what we did. So I'm going to start adding a little commentary to each of my videos after the formal stuff ends. Hope you like it. Look forward to reading some comments. We'll see you next time.